Hello, everyone, and welcome to this special episode of ImmLight of All Circumstances. I am waiting for my co-hosts to join me. We do have a special guest today. Hello, Will. Hello, Zainab.
Hi, Lou.
Hey, how's it going? We're waiting for everyone to trickle in. We know we sent the link out a little bit late, but as all these secrets and good things happen, sometimes you have to wait a little bit for these gifts. So hopefully everyone's on LinkedIn and Twitter looking for the link and joining.
Absolutely. So, why don't we get the show running, Will?
Absolutely. Well, welcome to the special episode of ImmLight, Catching the Chinook. There's been so many amazing developments, and we wanted to talk about it today. Before we begin, I wanted to recognize that I'm speaking from the traditional, ancestral, unceded, and stolen territories of the Musqueam, Squamish, Tsleil-Waututh, and Kaikat nations here in Burnaby/New Westminster, British Columbia.
And I, together with Zainab, I'm speaking to you from Toronto and Mississauga and the traditional territories of the Mississaugas of the Credit First Nations. And we do recognize that immigration plays a crucial role in the settlement of land and in the continuing colonialism that happens in Turtle Island.
Awesome. Well, listen, it's good to see you guys in the holidays. It's good to be able to have a discussion with you about all the developments in Chinook. We also have a special moderator today. Lou, tell us about how this session is going to work. We've been so secretive about it.
Absolutely. So, yeah. Well, she's not going to be on camera with us. Her name is Candy. She's this amazing superstar of an immigration consultant working with Will over at Heron offices. And she is going to be catching the Chinook with us, but more importantly, catching your questions in the Q&A, and she's going to feed them to us so that we can comment or answer them. And if you have questions specifically to Mario, we would welcome them. So I'm really excited to be working all these different teams working together today.
Absolutely. We also have a new co-host, which I think we kind of alluded to in tweets leading up to this event. She will be the co-host for season 2. We are so privileged and blessed to have Zainab join our team. Lou, talk about the process and how come, why has Zainab joined us?
Well, Zainab is an amazing lawyer, first of all, who has amazing experience in judicial reviews and immigration solicitor side applications. But also because Will and I have projects and we want to diversify the voices in the same breath. We want to share the load with someone, and who better than someone who had such an amazing chemistry. I think that episode was really demonstrative of how amazing Zainab was, and it kind of like just worked without any question. And a little bit of an inside scoop, guys, that episode was I wouldn't say scriptless, but almost scriptless. And we really shot threw our punches directly, and it was great. Honestly, one of the best episodes we've done so far, I think. Would you agree?
Yeah, definitely one of the best. But like every new person joining our team, we have to, just like we're catching the Chinook and trying to reveal new information, we need to learn a little bit more about Zainab. So Zainab, tell us a bit about yourself and
Sure.
three
First
fun
of
facts
all,
about
can
you.
you see I'm blushing? Thank you, Lou. That was wonderful. I had a similar wonderful experience talking to you guys. And, one of the mysteries or silver linings of this pandemic is that we get to work with each other, having actually never met in person. But even though that's pretty much our first conversation ever, it just seemed like, we were so on the same wavelength and different practices, but we were thinking about the same issues that are really important. I am honored to be part of this. I'm really looking forward to the conversations we're going to have hopefully next year in season 2. I've been working in immigration for pretty much close to the last decade. And I had some previous experience while I was a law student too. And I do a whole host of different things, mostly on the immigration side. So as you said, both solicitor as well as appeals and judicial reviews, things like that.
Mm-hmm. Any other fun facts? We've heard the
Oh
academic
my
and boring
God.
facts, but what about the fun stuff?
Well,
What does Zainab do on a weekend?
well, it's a good question you would ask that, because I have a 5-year-old daughter, and I am in awe of parents who have limited screen time for their kids. But I will admit that along with watching, her shows, I have learned so much about the natural world. It's ridiculous. Like, I know what hermit crabs are. All of the cartoons of these days are like so much more educational than when we were kids, and it was just like stories of battles and whatnot. But yeah, I spent a lot of time with my daughter. She is studying online this year. We're working from home. And one of the things that I find really interesting, sort of work related, I think I spend a lot of time thinking about what the future of our work is going to be like. You're going to be talking about AI and tech today within the immigration context, but it also plays into kind of how we will be working with our clients going into the future. So spend a lot of time thinking about that and trying to figure out ways in which I can make my services more accessible for clients around the world, particularly given language barriers, tech barriers, and things like that. So, yeah.
And I'm incredible, and as a father of a young daughter myself, I mean, I think we're definitely. I mean, maybe one of the blessings of the pandemic has been the ability to spend more time with them, and not have to go to our physical offices as much. But thinking about the future for them, and a legal world where they're players, either as lawyers possibly, or in whatever role that they do, promoting it, growing up.
I'll tell you something hilarious. Over breakfast, my daughter today, she told me, "Mom, I don't know what I want to be." And she's listed a bunch of stuff, but she's like, "I'm sure I don't want to be a lawyer." And I said, "Why?" It's like too much work.
Too much work.
So I may or may not be setting a good example there. So,
all good, but too much work, Lou. I know that's something. Before we jump into Chinook, I know everyone's still finding their way to our platform, so we're going to start quickly into the sort of Chinook conversation. But too much work seems to be a defining factor of your last little bit, Lou. No?
Absolutely, especially in the last 30 days, it's really accelerated to a degree that I did not anticipate. Back in the summer, we were joking privately that I would be taking my first vacation in 2.5 years sometime in October. Turns out that didn't happen. In fact, things just got progressively busy, and yeah, it's it's a good problem to have, to actually stop taking new clients. It means that you're at capacity, but you want to be responsible, right? You can't just keep taking new clients left, right, and center. So that's kind of like what's going on. Had an opportunity to go to Montreal, reconnect with some friends, make new friends over at Acadie, where I had an opportunity to talk about, stats, about study permit refusals from different parts of the world, specifically from Francophone parts of the world. That was a very interesting conversation. What about you, Will? What you've been up to?
Well, it's been a crazy transition time, trying to figure out what 2022 will bring in my practice, but also trying to do some of the work with you guys around spreading Chinook, and just updating the public. And I know so many more applicants from around the world are being impacted, getting their temporary resident applications refused. So it's important that we be a source in correcting information, but also in spreading accurate information about how these systems work. On that transition note, we've got new manuals. I think that's been sort of one of the big exciting parts of Chinook, is we have now a more detailed and less redacted manual. So maybe Zainab, you can tell us a bit about your preliminary thoughts reading through the Chinook user manual in all its glory and detail. What comes out in your mind as high level takeaways?
I think it's fascinating, and we'll be talking about this throughout today's session, that this is not a new tool. From having read these manuals, which unfortunately is still highly redacted, so we have very little information, but we do see just from the volume of them that these training manuals were created from as I would say as early as probably 2019. And they're looking at providing officers with a lot of instruction on how to use this tool, and also, I would say, additional instructions on how to really process temporary resident applications, information that we don't necessarily see in the documentation that's available to the public from IRCC, right? So not just the forward-facing website, but also when we go through the manuals and try to understand what's going on. So these training manuals have some interesting screenshots. I'm not sure if we'll get to display them for you today, but they have, if you follow Lou, Will, myself, or Andrew on Twitter, you will definitely see screenshots that are demonstrating how parts of the Chinook tool are working. And I think we're able to sort of try to piece together a little bit in terms of how to structure some of our applications to hopefully be able to withstand this new sort of system in which they're processing applications. And also just, the page about decision making is fully redacted, but some of the information that we see that's next to it does talk about, the note generator, which is one of the big ones that I still have a concern with. And one of the things that, in addition to these manuals, what I've been seeing in the past 2 months is the decisions are becoming slightly more customized when we get refusals, but they're literally just taking other information from other parts of the application and putting them into that node generator. So the manuals, I think, have been really eye-opening for us to see how developed this tool is. It's not just something that's been rolled out and might be being used. It's pretty much being used almost everywhere. And it gives us a little bit of a glimpse into how the system works, but I think we still have to keep digging to understand more of what's going on out there. Yeah.
Absolutely. And I think from my preliminary views, the ability to discriminate based on gender, based on marital status, based on country of residence and origin, it's shocking. And I know, Lou, shout outs to Andrew Colton, Lou's amazing articling student, probably I would say one of the brightest minds in immigration coming up. Everyone should sort of follow Andrew.
But star for sure.
And Andrew's got some research on like how long they're taking to process these applications. I mean, apparently 6 minutes per temporary residence when they have automation going. What do you think about that, Lou? What are your initial preliminary thoughts about that?
I mean, the preliminary thought is that we had suspicions from a long time ago. We've always had suspicions that decision makers are not making individualized decisions to a certain degree, or we had suspicions that they are doing this in batches, for example, that it's not actually being engaged with the evidence that you're submitting. So the last few weeks have been nothing but a series of confirmations left, right, and center, which was really interesting, which actually allows me to transition in terms of revelations. Because way back when, Will started talking about Chinook publicly, and when litigation was starting to trickle in like bits and pieces of the information, and we're really in a vacuum still, guys. We not because we have a manual right now, we we do not actually. We're still in information deficit. What we did find out in the last few weeks is that module 5 that we talked about in different occasions, which flags certain types of words or phraseologies, basically allowing the system to flag certain files as carrying a certain risk. So there would be risk indicators. What's interesting is that we've been able to get proof positive that there is a connection between what's called Watchtower. That is an artificial intelligence interface that allows to use data to essentially flag certain keywords, for example, catchphrases that may be found in an application for temporary residence. And that's one other thing. And as a sidebar, I suppose, a lot of people think that Chinook is a study permit specific issue. And Will rightly pointed this out at Junior Refugee Immigration Lawyers Network, that it's not just for study permits, it's for temporary residence writ large. So it's across TR applications. And it's concerning because the deployment of this system is actually, and as we know, and I tweeted about this too, is in majority, for the most part, global South countries. There has something has to be said about that. And Will wrote a fantastic piece about Vespa, which is, if it were opposite day, Vespa would be the complete opposite of Chinook, wherein it's a system that facilitates study permit applications towards an approval. It's almost like it's shepherding it towards that, whereas Chinook is a gatekeeper. It allows them to triage. It's a processing tool, and this is the common misconception, unfortunately. And I'm going to use this platform right now to clarify that, sure, we acknowledge that Chinook may not be artificial intelligence. It is a processing tool. But what we're sure now is that there is an interaction between that processing tool and whatever artificial intelligence that immigration is using. So again, I end that point on, we still don't know enough. And there's a lot to be said about that. And we'll go into that in a bit later.
Absolutely. I think one of the big revelations, and I think LJ, you brought that up as well, but on our last ImmLight podcast, we talked about Okrin. The decision again is still pending. It's taken actually quite a while to write this decision, which suggests that even the federal court is treating this with some attention and care, given probably the context we may have helped generate around this decision. But we have an ATIP that talks about litigation strategy, that Department of Justice is looking for weaker cases to try and push through these, revelations about programs such as Chinook. What do you think about that in light of what we talked about last time?
I mean, from a perspective of governance, of actually engaging with stakeholders, with the citizens of a functioning democracy, I find it very curious that they would use the courts as their choice of forum. And they're clearly shopping for a forum by choosing whatever case that would be to their best advantage. To me, there are a lot of stakeholders, such as the Canadian Bar Association, for example, who would be willing to chime in on how artificial intelligence is a tool for processing, for sure. No one here, I think, in this group is saying that AI is inherently evil, but we do know that AI has its faults in terms of implementation. So my question has always been, why the cloak and dagger approach? Why choose to introduce this to the public eye through litigation? At this point, I really just have questions. I don't have answers. Again, information vacuum, right?
Yeah. And Zainab, I guess now that we know that even the Department of Justice strategic litigation team is looking at, hey, can we find some weaker cases to try and push forward new revelations and move that forward? What does it mean for applicants and for counsel who might have received a refusal and are considering the judicial review route? Any recent reflections on the judicial reviews that you might have going on and maybe other practices you're seeing?
Sure. One of the things that I have seen, and I think it's come directly out of the work that we've been doing for the past few months of raising awareness around this, is, the note generator is generating notes that appear to be a little bit more specific, but they're not really so. Like, they will just reference, like, in the study permit refusal, what university someone's applying to, or how old they are, or where they're working, right? So some biographical information is getting plugged into this. So things like that are happening, but I think that there's still that recognition that the error rate in this Chinook system, or in this kind of processing tool or efficiency enhancing tool that they have, the error rate is still quite high. And when we do take files to federal court, the settlement rates are still fairly high. We do get settlements because when a lawyer, a DOJ lawyer, is actually reviewing the documentation and reading it, I think they recognize that the evidence is not matching up with the reasoning. And I'm really curious to see how this is going to go forward. I read a little bit in terms of some of the potential that Department of Justice and IRCC working together in terms of AI analysis for settlements in cases. I'm kind of curious to know if Mary has any thoughts on that. But maybe we're going to head in that direction in terms of how they might approach future cases. And there have been a huge number of cases, and Lou and I might be able to talk about this if we have time, but compared to previous years, the number of refused study permit and also other TR applicants who get refusals going to federal court has increased. And we talked about this before. This creates additional costs, much more significant costs than if we actually allocated the resources for the officers to be able to review applications at the first opportunity, as opposed to the Department of Justice lawyer having to take up those resources, right?
Exactly. I'm also really interested, as the Toronto settlement pilot is actually going to be pushed nationally. We've already heard in the West and in Vancouver that this is being brought forward, but the request for the tribunal record before a leave decision is made is going to have some major impacts too. And judges find themselves with the whole slew of evidence and documentation before they make a leave decision on that, and it might affect, the settlement prior to leave of many decisions if that happens. The other one I think is interesting is maybe applicants need to start using Chinook as a weapon as opposed to just being on a defensive in litigation, right? Where maybe we should be including it in affidavits in advance, showing how some of this works. And sort of turning it around on the Department of Justice in our litigation. So things that I'm actually experimenting with as well on a couple TRV refusals from China and India. So these are going to be really interesting. Cool. So I guess I just want to reflect a bit on my end. Recently I've been looking at ATIPs from a couple years back, and we have to recognize we are still so late to the conversation. I think I may have I talked about the manual giving us more information. It's still, as Lou pointed out, such a small sliver of what's going on. And we're seeing manuals from 2 years ago, conversations and emails between officers where they're dropping modules of Chinook, like, hey, you need to apply mod 1 to this. Like, I think mod 6 will help us. We are 2 years behind. We're just learning things that they've talked about for 2-3 years. And our ATIPs, as great as they are, also are delayed. So we don't get information. We're getting information now from stuff that happened earlier this year and in years past. So I think it's a responsibility of all of us as practitioners to really get on the language and get on the data discussion, get on the artificial intelligence discussion, which is why I think we have, we want to bring in Mario, because Mario is one of the experts of all of immigration on this topic and knows more than we can fathom, and has spent hours looking into it. So we're excited for that conversation. Finally, Module 6, I do want to talk about this a little bit, Lou, and I think we had this conversation in the Okran DuPont affidavit. They mentioned that there were 5 modules that they're processing with at NIRCC, and then in our manual research we found that there's actually 7. So there's 2 that they haven't really talked about. Maybe do you have any insight, or either of you, on why they are not talking about Module 6 and Module 7, or what are they? Do we know?
Zainat, do you want to start off?
I can talk a little bit about Module 6, which was, I think, what they envisioned to be a quality assurance module. And if there were such a module, I would be extremely happy, because, a lot of the concerns that we have is with regards to transparency and accountability within the system. When whole spreadsheets are deleted, how do we ensure that the decisions that we're seeing in the GCMS notes are actually correct? Unfortunately, it seems like there were just too many bugs, and they never implemented the Module 6, which I think is very telling, and it's something that IRCC will have to provide, I think, a much more clear answer on. Some of their discussions and other disclosure has shown that they are sensitive and they are aware of concerns that we have, and they should also have, with regards to the use of these automated tools. But obviously, they've kind of, thrown their hands up in the air on this one, and not implemented or built out a quality control, a quality assurance module.
Mm-hmm. So it's in the works, possibly, but hasn't been finalized. And Lou, what do you think is in that toolbox? I know we're starting to build our own toolbox around Chinook, but what could the toolbox think? Oops.
Mute.
I think you're on mute, or we're not hearing you.
Sorry, yes, I'm on mute, which is the theme of 2020 and 21, it turns out. Yes, well, I'm going to take a pass on Module 7. Actually, I'll let you go on and talk about it very quickly. And, why don't we go ahead and introduce Mario?
Yeah, absolutely. And again, just as a concluding point on our early discussion, I think it's, in terms of the next steps forward, it is to learn more about what these modules are. We know that immigration has these historical data. They're using things like CPI. I know Lou was doing some research on CPI and the correlation with study permits. Well, we found policy discussions by RCC where they're actually looking at that as the foundation for how to decide policy. In this case, it was the expansion of the student direct stream. So the advanced analytics power of immigration is far ahead of anything that we know and we currently implement in our own practice. And I think that's, I would say, the closing point of that conversation. All right, we have a couple minutes before Mario joins, but I think we need to give Mario his flowers. And let's do this collectively. I know I wrote a bit of an intro script, but I think for all of us, our next guest, Mario Bellissimo, has been instrumental in all of us pursuing immigration, on a lot of our young lawyers going this direction. One of the most brilliant minds in Canadian immigration, someone I know who I read his books in law school, his commentary, learned admissibility law from him. And now the leading cutting edge researcher into artificial intelligence in Canada in the immigration sector, I would say. Along with Petra Molnar, I think we have to give Petra her flowers as well, someone who Mario works closely with, and combining it with an eye to litigation. So Mario's been part of some of the biggest group litigation in Canada on immigration issues, and I would foresee that some of this is going to intersect with the artificial intelligence space. He's a mover and shaker in our work, someone who government listens to, testifies at parliamentary committees, principal and founder at Bellissimo Law Group, also in Toronto. Everyone welcome Mario Bellissimo.
Hello, thank you. I'm blushing now.
Thank you.
And happy holidays
welcome
to all of you. Thank you for having me.
Oh, thank you so much for joining. Lou, do you want to talk about how the next portion of this conversation will be going?
Yeah, so there's been a lot of talk that Chinook is AI. That remains to be seen, and from what we're seeing is it looks like it's a processing tool. So we thought that the best person to actually talk about artificial intelligence is, as Will said it, he's doing some of the most cutting edge work on artificial intelligence work in the field of immigration. Last time I heard from Mario was actually at Acadie, where he joined us by Zoom. It was a very interesting and a very animated discussion between himself and Richard Kurland, who was there in person. And of course, David Chalk had all the chuckles on stage. So I'm not sure if Mario actually saw that, but it was a fun event. But basically what I want to do is I want to structure several points of discussion to sort of give a roadmap to everyone. Will, Zainab, and I will be taking turns to raise several points, but in broad strokes, they will be falling under three categories. First is the idea of advanced analytics. What is it, and what are the implications? The impact of artificial intelligence as a second point. And third would be the idea of convergence of all these tools that are in IRCC's toolkit. So let me begin by talking about advanced analytics with Mario. Mario, I was wondering if you could tell us a bit more about what we are learning on AI initiatives. I understand that IRCC has China and India, for example, as a pilot for advanced analytics.
Right. So if we go back, 2014 is when they began investigating this. We went from very generic legislation in 2015, which just speaks really to enforcement and management of immigration processing, to 2022, where we're expecting a global rollout of the triaging tools that we see in India and China right now. And these are predictive analytics. They try to predict where an applicant should stream upon application. What we are learning is that the first in, first out principle, as far as it still existed in immigration law, is likely laid to rest. So what we need to understand, if 38% of people are getting to the head of the line in tier 1, which is low complexity as opposed to tier 2 and tier 3, who's being left behind in tier 2 and tier 3? And what are the processing times? So with this amazing technology we have, and it's expansive, and then we can talk a little more about the exciting possibilities, they have the ability now to produce much better information, to make this much more inclusive, much more of a two-way conversation. And that's what we need to see, because it's an excellent initiative. It's had a poor rollout, it's opaque, and it's not outwardly following AI responsible governance. And that's disappointing. I've communicated that to the department. Whatever they're doing internally, that's great. But this is too important to mess up. So India and China have been, triaging. That's wonderful. Under officers' rules, those rules have not been disclosed. They're based on past decisions. Outliers are removed, but a data scientist is ongoing, retraining the data. What are the outliers? What is the adverse information? Is adverse information, for example, applying for an extension while in Canada? Is that going to stream you to tier 2 or tier 3? Their response is, we can't let you know this stuff because then people can game the system. My response to that is, if this is about triaging, what's the big secret?
All right. Well, that's certainly a lot of information in, I suppose, the last 2 minutes. And thank you for sharing those points, Mario. I would like to point out before I pass it on to my colleague, Zainab, that Mario has written fantastic pieces on tiers 1, 2, and 3. So if that all was like alphabet soup to you, we'll put a link on our Twitter account for those who want to have a look at Mario's piece. Zainab, let's talk about the impact of AI.
Sure. Mario, it's wonderful to have you here. And, it's actually great to hear this possibility that all these tools can actually be used in a way to better the system. But what I kind of wanted to ask you is, what impact do you think, like realistically, what are some of the impacts that you foresee these AI tools will have on Canadian immigration initiatives as we move forward?
So, it's a great question. We're at the precipice of an incredible change. So I liken this going back to the late 60s, where they had the white paper and they were trying to bring out immigration from antiquity to, what were the current trends and morals of the time and policy shifts. This is where we're at. So what's important when we're speaking about AI, we can't separate AI from digitalization. They run hand in hand. But striking a balance between algorithmic systems and an individual rights perspective, it's a challenge, but it can be done. There's incredible possibility, as I mentioned, but it's not a panacea. The technology is not neutral. So it needs to be programmed in an effective, diverse, specific, and inclusive way, because if it's garbage in, you're going to get garbage out. And that's what I think is lost. This is not binary. It's not 1 or 2, 1, 0, right, wrong. It's not scientific. And so the future is, we have enough international examples. We can look at, and I know we're limited on time, but I just want to list them so that it gets into people's parlance. We have border control in Europe. We have the Atlas model. We have the RCA model in the United States. We have the HARM model in New Zealand. We have enough international examples where this technology can amplify existing inequalities, further emarginate, and further distinguish between even different classes of categories in immigration. So the key is, you have to proceed strategically and innovatively. There is great guidance out there. And I continue to urge Canada, be a world leader on this. Don't back end this. Don't take the approach, look, trust us. We know how to roll this out. Give us time. And as you were speaking about earlier, this debate, this project should not be formulated in litigation. We'd like to avoid that. So the time is now. We're at a crossroads. I hope IRCC accepts the challenge, because I'll speak about it in a few moments. We need a bit of a culture change.
I couldn't agree with you more. And I think this is an opportunity, with all of these conversations that are going on, for IRCC to see that there are a lot of stakeholders out here that want to be part of that conversation and to help Canada be that leader. But taking it a little bit of a different perspective, how has your knowledge of these sort of backhand systems affected your approach, your firm's approach to the files that you work on and your practice in general?
So we have to appreciate there's a technocentric evolution now that is redefining what discretionary decision making is, what procedural fairness means moving forward. So on a macro, you have to look at this on a macro and micro levels. On a macro level, we're talking about collective advocacy, learning more about the technology, pushing for an AI definition. That's critical as a foundational piece. Pushing for more of this to be in legislation. We've had a recent regulatory amendment, section 9.1 of IRPR, but these are generic amendments and not be pushed through policy. And we need proportionate governance. On a micro level, and I think Will spoke a little bit about this, recording trends, submission drafting that speaks specifically and asking what technology is being used and asking for notice of that technology if it's going to be used in your initial submission. so that there is a legal requirement for a clear disclosure of any technological aid. And then things along the lines of challenging uploading issues. So if you're limited in a procedural fairness response, for example, because of the technology, that has to be raised in your submission. Any exclusion of counsel issues, where you as counsel, as a lawyer, have been in any way inhibited, and anything that stands between you and the rule of law and the delivery of legal services has to be highlighted. So let me give you one example. Immigration Canada still indicates that you should not leave original documentation with your lawyer. Can't be trusted to leave original documentation. Well, that immediately collides with our professional obligations under our respective law societies for document due diligence and ongoing assessment. That type of stuff has to be challenged. It has to be flagged. And as Will said, this has to be part of our everyday. So, you know, every time I get a chance to speak about this, I'm asking counsel at all levels to reimagine the practice of law with new layers, new contours, and new procedural rights. And that's all right now technologically framed.
That's great. Thank you.
So I want to turn to how it actually makes an impact on practice, for example. Actually, I'm interested on how this has affected, say, for example, in your practice of law, Mario, when it comes to backend systems. How have you adapted your own firm into submitting applications, for example? You talked about raising technological limitations to procedural fairness letters. That's an amazing example for one. What are the other things that you've done in order to mitigate, say, let's say, the advance of these tech tools that are in IRCC's full suite of tools?
So you're going to have to start identifying risk classifiers. And this is across all technology. What are those buzz phrases? What repeat either in litigation or in decisions? What words are you seeing? Those words have to be used almost like search engine optimization on websites, okay? Has to be used in your submissions to get you to the goal. Because let's face what's going to happen here is there is a push to get into that wonderful tier. That's the golden ticket now. Everybody wants to walk through tier one. There's going to be, that's to the benefit of applicants. It's the benefit to you as a lawyer. You're doing the best. So you got to learn those risk classifiers. And you have to realize that the data mining, okay, it's the new oil. It's today's new oil, but it's about the extraction process. So what is it that they are looking for? Every question on those boxes down on forms are being data mined. Department maintains the data collection is not AI driven, fair enough, but the data collection will push AI and the formulation of these rules moving forward. So this is important. We also have to be aware in our practice, because I think this is an exciting time. I don't see this as a negative time. I see this as a time where we can reimagine immigration, an immigration system like nothing we've seen before. It's fantastic. But as counsel, as lawyers, we have a real responsibility to make sure they take the right road. And so what does that mean? We're going to be looking at chatbots in the future. And we're already seeing that with CBSA. So what's the chatbot? There's going to be an algorithm on you as a lawyer. There's going to be algorithms on how people find out certain information. So we have to understand and push for plain language algorithms, okay? We have to ask for disclosure of this information. And we have to continue to push for that. Now, also in your practice, you have to start looking at, and again, this can be through larger organizations or small, for AI solutions in your own practice. AI versus AI. This is the new world. And remember, the technical solutions, as Petra Molnar has said, are as diverse as a country's democratic values. So what's playing here in North America and what's playing everywhere else is a real challenge. And keep in mind, one last point on this, 70% of AI-driven expansion is either in China or North America. A lot of the world is left behind. UNESCO tells us 22% of AI programmers are women. So if you ask yourself, why is Siri and Alexa in female voices? They're reinforcing gender stereotypes because of who's programming. So as part of our practice, Lou, you're asking who's running this, How have they been trained? Who is the public data officer? ESDC is actually doing a little better than IRCC, at least in positioning people. All of this becomes important. I want to know who's created this algorithm. I want to know that, and hopefully I can find that out without going to court. But if I get into court, it's going to be one of the first questions I ask.
And that's a great
Those are really fantastic points, actually. Sorry, Will. I do have one follow-up. I promise it'll be brief. Can we just agree here, the four of us, that data is hardly neutral at any point?
Mm-hmm.
Like, these are human constructs, so it's very disturbing to me that to me, is a kind of like as a comment to this, to what Mario has shared, is that if AI systems are basically going into data mining, for example, and that's the direction that immigration is going forward, and there are no checks in regards to the neutrality, or quote unquote neutrality, of data and data sets for further data analytics, then it begs the question, what basically keeps the system running without the biases that are embedded in the data themselves? There's an old Latin precept that I can't remember now, but in English it largely translates as who guards the guardians. So it brings me to our next point, actually, on keeping the guardians at check, which is litigation. Well, you want to talk about that?
Yeah, Mario has a track record in litigation in the federal court, and I wonder, as I have these same thoughts, as we start bringing in AI-based arguments, how do you see a court that, I wouldn't say our courts right now, I mean, they're making great progress towards it, but in terms of, if we think of us as just being behind, I would say the courts are probably just around us and maybe even more behind in terms of modernizing. But how do you see how the courts might apply a Vavilov framework to an AI decision, and where do you see litigation going generally? I know I've at least gotten many more inquiries from group litigants, hundreds of folks who believe they've been refused at the same time using the same process. What are you seeing from that in terms of opportunity and process on your end, Mario?
Great question, Will. And again, I want to break this up at both a macro and a micro level. At a macro level, UNESCO, charter on AI ethics, New Zealand charter, they all speak to appropriate redress mechanisms. So algorithmic impact assessments are critical to be rolled out before any adoption of a tool. I believe in time, and I know this sounds like a dramatic statement right now, but whatever algorithmic charter we adopt in this country, and I hope we do, it might one day be as important as the Charter of Rights and Freedoms. Mm-hmm. That's where we're headed. I'm not sure that funneling all this through a standard review, judicial reviews, that more innovation might be required. Perhaps expanded appellate relief from the IAD, perhaps access to international courts. There's going to have to be some innovation on a larger level, because I'm not sure, unless there's further adaptation to what's happening, you might try to be sticking a square into a hole. But to Lou's last point about the neutrality and embedding biases. So we've learned that AI, for example, is fantastic with combating COVID. It's been fantastic with dealing with climate change. But a quick example, in Stanford University down in the States, they were running out a mechanism to roll out vaccine distribution. And the AI algorithm spit out that all the administrators should receive the vaccine before the frontline workers. And why was that? Because the administrators programmed the AI. So when it comes to the litigation, Will, I think we're going to live and breathe into things that can become relatable on a plane that's relatable, an informational plane that's relatable. So who programmed? Was there human oversight? Can you confront the witness? What's the transparency? Is there plain language? Is the person even implementing the system know it? Because right now we know in China and India, officers are not exposed to the officers' rules. They don't even know them. And they are not told how they are applied. Not sure how that works in terms of proxy decision-making, triaging. And let's look at some litigation I'm involved in right now. Applicants that selected the the English stream ended up in the French stream. So let's say there was even a box that was checked off incorrectly and the applicant accidentally checked off French stream. Was that an auto refusal? Because everywhere else it said English stream. So this is already starting to tweak my interest as how much of this at a certain point are auto-generated refusal. And you've already mentioned this earlier in the podcast. The generic reasons are becoming almost commonplace. I'm seeing 20 a week now, where they're usually automatic settlements. I think the government is perhaps playing a risk mitigation strategy. How many can they get through and how many will be challenged? All I can encourage is any applicants that are out there and lawyers that are out there, keep challenging, make it difficult to run these types of systems where they bank on most people not challenging.
Mm-hmm. And maybe if I could take you a step further, just because these things are coming up, if you were working with a TRV refused applicant in China and India who you believe may have been tier 2 and tier 3 sort of at this stage, do you think you have enough tools with the current federal court regime and with the standard of review and with all the, I guess, even the federal court rules, the way they're going, to be able to put your applicant's best case forward? Are there things you'd like to see change to allow to provide you with a better opportunity to make that argument for your client?
Yeah, well, you mean from the IRCC's perspective, the information they're providing, or the actual?
I just in federal court, I mean, all the rules around not being able to provide new evidence. I mean, we pretty much would have to file affidavits to try and get our applicant's position forward. But I don't know, are you seeing other strategies we could utilize to try and get government to show their cards?
Yeah, so I think by raising the argument in your initial pleading, hopefully, if you inherit one of those, that allows you to go through the procedural new evidence, procedural fairness exemption, and then be able to bring in evidence of all of this other stuff that's going on, which is great. The other thing that we have to consider is, as lawyers, is when do you go from an application to an action? Because an action obviously allows for much more explosive discovery and questions. And so there's that strategic decision where we're seeing, and even for this TR to PR pathway, if we see a real big trend and there's not a settlement, that might be something that has to be contemplated as a potential litigation strategy to understand more about how the system is working. I think right now, they are trying to move cautiously, and their belief is they don't have enough to show right now, but it's still backwards. This should be a discussion that's being had with stakeholders like the CBA, other organizations, AI governance before rollout. It's been established internationally. I'd like to see Canada follow it. Otherwise, we're going to be in litigation and getting this information there. And then we're going to be bringing in AI experts that say, what's good governance? Let's bring in the New Zealand Charter. Let's bring in the UNESCO Charter. Why wasn't that followed? What has happened in other international examples? And I wouldn't want to be on the other side of that case if I'm the government.
Wow. And Zainab, I think you had some questions for Mario about convergence, because I know we've been sort of pushing the Chinook front, and Mario's talked a lot about AI, and there is the convergence as Lou was talking about earlier.
Absolutely. We've been talking about Chinook for the past pretty much 4 or 5, 6 months, but before that, there wasn't a lot of information that was disclosed about this particular tool. There are other tools as well. I wanted to ask you, given what we have learned little by little over the past few months about how these efficiency enhancing tools like Chinook are being used, how do you think this is going to play on the back end in terms of working with AI and the impact it could have in terms of processing for applications?
Excellent question. So these are leading into what is going to be, this is all going to be AI in a few years. So it's really, you have to be really careful when you're dealing with these issues with the government to ask the questions. Is Chinook AI? Well, Chinook's an Excel data sheet, so it's clearly not AI, but is there interaction? Is there an interface with AI? Are there AI connections that are going to flow from it? And the answer is yes, yes, and yes. And why? Because this data that they're collecting is going to fuel those officers' rules. It's going to provide not only triaging, but as you're already seeing, the auto-generated refusals. And you spoke about this. What I don't like about these systems, and I understand their GCMS workarounds and it's antiquated and they want to move faster, That's all great. We want productivity wins. We understand. But the push can't be to the no. The push has got to be to the law. So all of these things that are happening when you're challenging things like Chinook and other things is, where's the legal basis? Is it in legislation? Is it in regulation? No, it's in policy. Reading the transcripts of the cross-examination, they didn't even have their legal counsel present when they cooked this up, right? And remember, this was following Haraya, which I know we're going to speak about in a moment. So Haraya is the kind of predecessor to all of this. But so these are policy driven. So any of these qualifiers they're using, there has to be, the law's pretty clear. There's got to be reasonable departure of the application of policy. So you may even want to ask, going back to strategic considerations and convergence, that you don't want Chinook applied. You want a reasonable departure from Chinook in this client's case. Why? Maybe there's some different factors that you don't want their risk classifiers to do that. And the type of redactions that we're seeing, very disappointing. Just be clear. What are you using? What are the classifiers? We're here to help. We want to all have an inclusive and diverse and robust system. Let's move forward. Final point on this with these types of tools. Australia years ago, when their system, and you may all be aware of this, but when their immigration system was collapsing, they introduced what was called the College of Immigration. And they sent all their officers to be retrained at this college in facilitation as opposed to enforcement. And they became a world leader. And all of a sudden, we're copying a lot of their stuff, but that's one thing we didn't copy. I think we need that, because these types of tools are an example that officers are trying to be handheld to such a degree. Their discretion is being so confined. To me, it's bordering on unlawful, and it's ultimately not helpful. Mass processing, in my view, is the opposite of justice. There's better ways to do it. Leverage the technology in ways that enhance that. And I've spoken about this in my papers. Get away from ATIPs. ATIPs were never meant for an ongoing check on your file. Enhanced access. Let us allow peek behind the window. All of a sudden, as lawyers, we can say, oh, by the way, we noticed you missed this, we can fix this. We can do this. Now we're talking. Chinook, Haraya, it's so 2000 that we're so beyond it. It's not even worth the type of investment they're putting in. I'm sure I'm not going to make many friends at the department saying this, but I think we should move on.
Actually brings us to the question. Not a lot of people know about Haraya. What is Haraya?
So Haraya was like the almost like the poor predecessor of Chinook. It started in Manila. It was another GCMS workaround. Same thing, mass processing, everything on a big dashboard. Okay, so they could see it all at one time. But then you're profiling, right? You start getting into dangerous trends. And remember, we have to think of ourselves in the officers' mind sometimes. Imagine coming in every single day and seeing that same dashboard. How are you retraining the officer's mind to profile and to push for the no? So there was a whole view screen. There's pre-assessment tools, and then it moved to Colombo. So this was in 2016, 17 in Manila. 2018, it moved to Colombo. And in Colombo, they didn't have specific assessment templates for work permits and study permits. So they were still using the internal Colombo templates that, of course, no one knows about, that you only find out about them in ATIP. So this was the first start into this whole let's work around GCMS and have everything on one screen, automated, pre-generated refusal points. And the ATIPs are very clear that as soon as the global tool is rolled out, which we now know is Chinook, it's collapsed into that.
It's really interesting. You said 2016, and perhaps I can provide better context here. I was in Manila in 2016 for a quick family visit. The internet was awful. So I can understand why they developed a tool like Haraya to work around GCMS. And we all know that GCMS is already clunky as it is. And imagine that working on a 56K modem type of speed for your internet. Even if they're at RCBC Plaza, which is the building where the Canadian Embassy is at, I don't think they're going to get T2 level internet that actually gets around that bandwidth issue in the Philippines. The other thing that you said, Mario, that really struck me is if they're doing it repetitively, there's this thing that Maria Ressa, the recent Nobel Peace Prize winner, said in her acceptance speech. It's called behavioral modification strategies that all malevolent trolls are doing online to basically get people to fight against each other. It sounds as if that, this process of having to do this day in and day out for 7.5 hours every day for 5 days a week, it will definitely change your outlook. It will definitely change your behavior. Which allows me to essentially get me to pass the baton to Will in talking about outlook. Why don't we move on to crystal balling this?
Sounds good. And again, Mario, to frame this last question that we're going to ask you, and thank you so much for taking your time. I think this is a type of CPD and lecture that I don't think we could even register or pay for it in Canada. So I hope listeners know you're getting the creme de la creme of information here. Sorry, my French needs a little bit of work. It's my plan for 2020. We have a lot of self-rep viewers, right? Those individuals who are around the world, particularly in the global South. And, we don't want to lose them in this conversation because some of them will be like, these are big words. These are big international charters. These are things, let the lawyers lawyer. But I myself am someone looking to consider Canada as a country that I want to immigrate to. And this is scaring me. And all of this discussion, I'm getting this pessimism and fear and that everything is AI, everything's inevitable. They're going to refuse me for sure. Maybe I shouldn't even be applying to Canada for immigration. What would you say to someone like that? And how are you dealing with that sort of more practical conversation in your own practice with clients who are asking?
So if the technology is leveraged properly, Canada is already, obviously I'm biased, but one of the greatest countries in the world. If the technology is leveraged properly, the process should be a lot less painful and should actually be enjoyable and interactive, like some other countries that have, taken a little bit of a step ahead of us in terms of processing. Processing time should be reduced. Plain language should become the norm. Expanded access to your file as you're going through it should become the norm. Balanced information about who you can trust to help you with your application where you need it, instead of putting the fear into people about using any representative because so why not just go to that person that's charging less and making it sound easier? So I'm actually inspirited. I'm excited about this time. I know there's some work to be done. There's some pushing to be done, but I believe the technology is going to mitigate some bias. I think it's going to also take away some of and there was the recent report from within IRCC that they're worried about automation, further embedding, increased automation, embedding further discrimination and bias within their own department and in the treating of files. So this can be, again, now let's talk about what this looks like. For example, if you have a person who's outside, and this is what AI governance calls, peer-reviewed, public-facing, you're able to access the systems, plain language, this could be a really exciting time. And so to the self-represented applicant, I say, stay tuned. I think Canada is going to be better than it's ever been once we sort this out.
Wow, that's some hope. That's a big crystal ball, and that's I think gives us some hope, especially as we've been sort of more, I would say, moping in some of the more negative consequences of Chinook. To hear that AI is going likely a different or possibly a different direction, it gives us some hope as well. Lou, do you want to say any final words to Mario to thank him for his appearance on today's special episode?
Well, we're not letting him get away just that easily, are we? We're going to do a Q&A. We have a lot of questions, actually. Shall we jump in directly?
Yeah, we can just, why don't we jump into questions, and maybe there's some for Mario, given we have a few more minutes of his time, hopefully.
Sure.
Absolutely. And thank you for sharing your time with us, Mario. We know that you have a very busy schedule. And, as all business owners, you, myself, Will, and Zainab here, it's the end of the year, and the end of the fiscal year always brings joy to ourselves and our accountants. So it's always a fun time. So let's jump in. We do have a few questions here. I think I'm going to rephrase, I'm going to read it first and try to kind of like spin it to something that plugs in directly to our discussion. So, from Truth First, I got my GCMS notes, and it is written that motivation letter is vague and generic, and do not clear that there's no clear career path, and study plan is not reasonable. So, I think this plugs into what Mario was saying, that he was receiving what on average about 20 of these generic letters at this point. Can we talk about this, please?
Yeah, so anytime these letters don't make any reference to the actual country, to any specific personal identifier of the individual applying, that's a clear sign that it's likely been, depending on where, and soon it'll be everywhere, where it's been triaged and that it's been Chinooked. So that's fine. Those cases, well, it's not fine in terms of that they're doing it that way. It's fine in that that's not going to stand up in court. Those are quick settlements. It's unfortunate. I think as lawyers, we're trying to set the bar lower to try to get to these settlements in an economical way for individuals so that they can resume their lives. And I think, again, as I stated earlier, it's really important that we continue to challenge all of these, make it difficult for them to run a system like this. So again, it's difficult right now. We've got to trudge through this, but there is hope. And I think this is not sustainable for the department because it's like anything, right? 20 cases is one thing, 500, 1,000 challenges. Then the DOJ starts saying, look, this is just not working. It's too much, going back. And then the next question, of course, when it does go back for redetermination, you're going to ask that the technology not be applied and that it be screened for immediate review and not be triaged, so that, again, you escape any technological aid, or at least you put them on notice that you want to escape that aid.
Can I just jump in really quickly here? Sorry, Lou, I know you're trying to get to the next question, but Mario, as I mentioned, in more recent refusals, the notes that I'm seeing, we would see from similar visa offices exactly the kind of refusal that Lou just mentioned, very generic, no reference to biometric information, like nothing specific. But do you think that as Chinook is being, that note generator is being tweaked and there's going to be more specific information with regards to the actual applicant? Is that going to fool the system into thinking these are actual notes when they're just literally, like, again, pulling things from different possibly columns or fields in that Chinook tool? That's a question I'm thinking about. I'd love to know your thoughts.
That's an excellent observation. So they're definitely going to try to better enhance the reasons. But the difficulty they face is, without extensive officer retraining, it's still stating a series of conclusions with no analysis. And that's where the reasons ultimately fail. Logical progression of studies is already a tenuous ground, as one example. You have to have a pretty good explanation as to why that would be a reason. So for them to work up the system to that point, I think it's going to take a lot of work. So I don't doubt that they're trying. I'm just not sure they're going to get there. And to get there, is it worth the investment? I think it's just better to go back ultimately to categorizing, using some of these reasons, but then having manual review. I've started comparing, I do it in my papers and I do it in litigation sometimes, showing the same reasons from different offices. And that's been, I think, very persuasive. But yeah, we'll get there. Now, AI may be the game changer, because AI, Zainab, may allow for much more sophisticated reasoning in the future. So this system, no, give it a couple of years, we might be a little more challenged with what AI can spit out. But my worry with the AI is that because it's going to be used on past decisions and training, and as you may know, they can't control the predictive analytics. So that's the interesting thing about AI. You can't automatically predict what it's ultimately, once you've given it that deep learning, that ability. We've seen it in other applications where it actually picks up hate speech or segmented algorithms where people are ultimately excluded. So I think we're a number of years from getting to the point where they can do mass processing. But again, if they leverage the technology right, you can get enhanced reasons that are meaningful to applicants, and it's balanced. It's not about refusals. Hopefully that was a long answer. I'm sorry, but that's kind of where we're at.
Yeah, thank you.
That's perfect. Thank you so much. Before I move on to the next questions, what I'm going to say is we're going to take a little bit of the heat off Mario. What I'm going to do is I'm not going to go into questions in order, but rather by category, and then we'll deal with the other ones ourselves. Now, I apologize. I don't have a glass of water like Will. But the next question I'd like to pull from my colleague, Andrew. Mario, if you were a pie in the sky dreaming of how to do an action instead of a JR over AI triage or use of Chinook, what would your dream action litigation look like?
I'm going to say to Andrew, please call me on that. I don't want to broadcast my dream action. I know where he's getting at, but I welcome the conversation. Let me speak in a very generic way, which is consistent with some of the things we're discussing. I think it's the ability to really, and I know this may sound very generic, but it's the ability to bring in information that is currently not within the conversation between the applicant and immigration, to basically almost shame or show how deficient the program is, while trying to educate the court on what procedural fairness in 2025 and 2030 is going to look like.
Mute.
I believe you mentioned procedural fairness 2.0 at some point, Mario.
Yeah, I refer to it as procedural fairness 2.0. I refer to it as plug and play will keep the lawyers away. These are some of my buzz phrases.
I love it.
So that's, yeah, those are a few that I've used. Again, I say this in all seriousness because I don't think it has to be that way. I'm happy to sit down, and I have had the privilege of sitting down with some of the top officials, and I know they're well-intentioned. They're not sitting there for ways to devise and make things difficult. They're all trying to win. They're all trying to be the productivity hero, and I would want to be that too if I was in immigration. I want the system to be better. We all do, but I think there's things we can learn from each other.
So a couple more AI questions, I promise. So there's one's really interesting. Mario mentioned using AI in their own practice. So AI versus AI. Sounds like spy versus spy, doesn't it? Can you expand more on that? How would we avoid on our end the same concerns, pitfalls we're seeing from what IRCC is doing? And I believe this one's from Alicia.
Well, thank you, Alicia. It's a great question. Now, we already know some big law firms like Denton's and all the rest are already heavily investing in AI and in e-discovery in a lot of different areas. So the problem that we sometimes have with considering AI for smaller practices, AI means big money. So, we're kind of left in the dark. Well, not necessarily. I think there's some platforms that are slowly developing that are going to help us with at least some modest gains. Trend collation, being able to canvas certain litigation patterns, much like DOJ are trying to do in H&C and PROS. That's one of their one of their initiatives that are going on right now. So I think there's things that we can invest in that are more modest. I think there's the suppliers know that there's a big market. I've had some conversations with some suppliers, and I'm encouraging them. Some of them are outside of Canada. I'm encouraging them to target immigration because I think it's a win for them. I think it'll be a win for us. So like many other things I've been saying, stay tuned, but I think there's more things to come, and it's all about getting it to be at a level that's affordable, because if you're a firm like mine, we only have so much resources. We're trying to do what's right. We don't have $100,000 budgets for litigation. So, we got to stretch the dollar. But that's what eventually is going to happen. So the next 3 or 4 years, I think we're all going to have AI aides in our own offices in some form or another.
One more AI related question for you, Mario. We know that advanced analytics is being deployed or is currently being used in China and in India. We're wondering, are there other specific offices that it would be rolled out to in the future?
My understanding is in 2022, it's being rolled out in almost every office that can technologically support it. That is my latest information.
Okay.
So pilot has become permanent.
I see. Okay. Well, I think I've run out of AI questions. Are there any reactions from my dear co-hosts here on the AI question?
I got to start reading. I think that's just the number one. I think as practitioners, we gotta get. I don't know what my winter break plans were, but it's to probably follow the Mario playlist of reference guide of resources. And I know, Mario, you've been just so grateful.
Turn it into an audio book on Spotify and turn it into
AI
a Christmas
generated
playlist, right?
Yeah,
exactly. AI generated, beautifully curated by Chinook.
Yes.
Yeah, but I just, that's my takeaway. I think it's we got to do our homework, right? As lawyers, especially if it's going to all the visa offices in 2022. This is going to be most of our clients now, and are we prepared? Question mark. I would probably say not at all right now. Not at all.
I find that fascinating that it will be rolled out everywhere, because we do have an understanding of there are different types of, well, not different types, but there are different volumes of files across the world, and the level of data that they're going to have to plug into that system and do the triaging. That's like the first question that comes to my mind. But I agree with my colleagues. This area is moving so fast, and I feel that I hope we played a little part in trying to raise awareness about it, but it's something that all of us constantly will need to stay on top of, because it will impact every aspect of the kind of work that we do, and to be able to really represent our clients and be able to advise them, we need to understand how it works and the best ways within the context of any particular point in time that we can assist them.
Well said. And I would add, don't fear and don't assume. You have to have a very open mind to this. And the focus has to be not about us reaching and becoming data scientists. It's about making it relatable for us. So it's a counter pull. And that's what I encourage people to do. Ask the questions that they're explained so that we're not left out of the conversation, which is very important. I will add a caveat to my point about the global rollout. My understanding, that was pre-Omicron, so I don't know how much that may play into it, but that's the information that I understood, and what that means, and why wouldn't it be? I mean, I think, and it's important to take in mind, Zainab, you raised an important question about globally. It's tricky because although it's the same algorithm in China and India, it is a different model. So there's a lot of work that has to be done to make this work. And in their view, they're simply triaging to help, which is important. But I think, again, if we get a little more information, I think we could really help them with this rollout and be in the room.
Yeah.
Thank you so much, Mario. And as this is a closing, to thank Mario. One of Mario's great mentors, and I've been grateful to be able to listen to a few of those stories, but Cecil Rottenberg, considered the grandfather of Canadian immigration, and Mario, to many of us, has become a bit of a father figure in this work. So I want to thank you, big brother or father, depending on our ages, but thank you so much for enlightening us today on ImmLight. And I think, just thinking about all the other podcasts I've heard, you probably dug deeper than you have and given us more than in even the other appearances I've heard you in. So I want to thank you for that. I think the listeners are going to take so much away from this.
It was my pleasure to spend time anytime with the three of you. I thoroughly enjoy it. I ask everyone to listen to the Styx song, Mr. Roboto, if you ever want to understand more about this. That was written 30 years ago, showing my age, but I think it has some answers there for us. Want to wish you all the blessings of the holiday season, as well as to stay safe. And when I join a podcast like this and I see the great young minds that have decided to thankfully enter the world of immigration, it just energizes me to want to do more and more. So kudos to all three of you for all the incredible work you've done. And I know this is becoming a mutual congratulations session, but I think it's important to say for your viewers, they need to understand how much you are all impacting people's lives and future generations. Cecil would have loved all of this. I'm sorry he's not here to see it, but we carry on in his name.
Thank you.
Thank you,
Thank
everyone.
you so much, Mario.
Thanks, Mario.
Bye-bye.
Bye.
Take care.
All right, everyone.
was
There
fun.
you have it, Mario Bellissimo.
Wow.
That was, I'm blown away, Will. What about you, Zainab?
That was an amazing conversation. And I can't believe we just went through just over an hour. It feels like we just started.
Mhm.
Yeah.
No,
I'm
don't
very
worry, we still
inspired.
have a lot of questions,
Yeah.
so we'll run through some of them. I did promise our audience,
Okay.
and thank you so much, everyone, for sticking towards the end. We're about 15 minutes left, so we'll try to parse through some of the questions that were posted to us, and then we'll do our closing. So let's start with some of the practical ones. There was, first of all, a shout out to Zainab. It's really nice to see you as the new third co-host of the
My
show.
pleasure.
Yes, agreed. So there was a question here in respect to, let's see. So it's in regard to the use of Chinook as a software and when triaging, let's say, a study permit application. And this one's from Truth First. Do they actually even read the study plans anymore? And maybe Will can answer this.
Ooh, I mean, I think I hate to use this word. And again, I want to put a caveat that Mario's like, his answers are another level. We're trying our best here, and
Yes.
we're probably not going to give Mario level answers with all the like litigation thinking in the background. But I think it really does depend on what visa office, their volume, the officer, whether they've pre-sorted or not. Based on what I'm seeing, I think they're spending probably 6 minutes on some applications, but probably 2 minutes or a minute on others, right? It's not going to be consistent across the batch. But there are internal correspondences from immigration saying the most important thing in an application still is a study plan. So we still
That's
see
right.
that communication. They are supposed to look at it, and it's important to summarize those well and nail down the main points. And the officer can read in a couple minutes why you want to come and study. Especially, we know why these are getting refused, right? Duplicative studies, mature student, different study, available options at your hometown. Like, you should be able to address those in a couple minutes in an application, just so an officer can see. Any thoughts on your guys' end?
The one thing I will add here is I would love to think that they do read them. But even if they don't, they're extremely important for the, as a student or as a practitioner for you to put these together, because, the reality of the situation that we're in is, unfortunately, if somebody does get refused, one of the most realistic options of being able to get to a positive decision is to go through federal court. And in federal court, I would say the most important document really that we always start with when we're trying to put, a piece together how we're going to defend an application is the study plan. How well was it thought out? How detailed was it? Does it address the questions that, Will mentioned? And then go to the documentation that supports that. So I think it's a very important question of do they actually read it or not? But I would also say, irrespective of that, and whether we can determine, because right now you can't tell from Chinook if an officer has in fact gone back and looked at the actual documents or not. We don't know. But even if they don't, that could be the document that makes all the difference in the end.
Yeah, I wanted one more point then, Lou. I'd love to hear from your perspective, but I'm also noticing in my practice a shift between, when I started, even just a few years back, I found that the submission letters were sort of where we put everything. And it was always like the lawyer speaking for the client. And sometimes we put a short letter for the client. I'm switching around that totally. I want my client to say, I will comply. Right? I want my client to say what they want to do. It's not for me as a lawyer representative to put words in their mouth. And I think when I go to court on it, I want to be able to say, hey, the applicant actually said this versus, as a lawyer, I said that they would comply, which I can't force anybody to comply. Right? So these are some of the little tricks and tips. And I hope that, we see stronger study plans. I'm actually giving a talk on study plans next year, not to put a plug on that. We'll share the link. I'm speaking to the CBIE, Canadian Bureau of International Education. I know schools are working to try and help students improve their study plans as well. And I'm going to be providing a lecture and workshop on that.
Very important that these study plans are actually done properly. Absolutely right. And my point to that, Will, is it cuts both ways. These study plans, first of all, are they reading it? One would hope so. I take my friends' positions here that you would want to think that they do, and it really depends on the visa office that you're dealing with. On the volume, for example, regardless of the fact that they, whether they read it or not, that's not important. I want to highlight the responsibility of the person who's actually writing the study plan.
Mm-hmm.
In the last few weeks, I've had this parade of consultations, and it's interesting because a lot of their study plans are 9, 10, 11 pages. And quite frankly, if an officer is, as we know, on average, and let me put a big asterisk this, on average, spends anywhere between 6 minutes to 11 minutes to look at a study plan, do you really think they're going to read your 11-page study plan? No. Get to your point. Strictly, 2 pages, 3 pages, just get to your point and make sure that it's very clearly communicated. No fluffy language. Let's put it this way. If you're a visa officer and you're doing this day in and day out for 7.5 hours, at some point your eyes are probably starting to, twitch, just like reading the same thing over and over again. Essentially, and you're stumbling with study plans that are not well written. You're not helping yourself. So just get to your point. And as Will mentioned, I think it's very important from a practice perspective that we need to lead with our client's voice. Our role as counsel when doing legal submissions in support of a study plan, for example, is really just to give the juridical basis, the legal basis, the legal supports that what your client is actually saying. So let's move on to another question, shall we?
Can I just break in, because we have breaking news?
Sure,
and that's kind
absolutely.
of what our system is. The mandate letter to the Minister of Immigration has just been released. So I just posted a link there just for folks to, hey, just happened to be during our show. They didn't do this purposely. No, but, there's some interesting stuff there. Minister. Yeah, I just, we should get the minister on our show. Minister, come to our show. But no, some interesting stuff there. I think it's worth taking a look at for those who are watching and those who will watch us later. Really interesting stuff around working to strengthen family reunification by introducing electronic applications, which they kind of done, but implementing a program to issue temporary residence status to spouses and children abroad while they wait for the processing of their permanent residence application. I'm hopeful. I'll keep it at that. I'm hopeful. We needed that in writing, and I hope they do that because I know that's a big issue. I know it's a little bit different than our Chinook conversation today, but it still impacts it. That a lot of family and spouses are being refused and not allowed to come to Canada. Pending permanent residence.
All right, so there's another question here. Said that every document was actually included in the application, and this one's from Mohammed Shabar. Thank you for the question. It said in the GCMS note that he's not sure where he completed his degree. He says that the documents were there, but the officer is saying other things. Maybe let's start with Zainab this time. What would you do?
Assuming that the applicant put the application together himself and is confident that the documentation was provided. And usually with respect to education, it's one of the only pieces of information you input into the forms, because we know that the way the Chinook system works is that it pulls the information from the forms. So you want to go back and make sure that when you completed the forms, you in fact put that information in correctly. If it's clear that the officer missed this information and it was definitely in the application, I think, you could try to request reconsideration. We haven't really talked about that, but a request for reconsideration is an informal process where you can try to write to the visa office and explain the error that they made in the application. Previously, these requests for reconsideration were actually processed. They used, it's the idea that the officers actually had some time. They would go back, look, and they would come back and say, yeah, sorry, we made a mistake, and they would issue the passport request. My experience over the past 2 years really has been, because of all this volume pressure, even when you do a request for reconsideration, you're very unlikely to get a positive response. And you have a limited period of time if you want to take your file to court. But I provide this sort of, as an idea of, having complete set of options before you. But I think in a case such as this, where it's a clear error, if you take it to federal court, you are likely to get settlement fairly quickly by being able to demonstrate that documentation information was in fact on file. And something important that they've clearly highlighted in the notes, I think, that would probably be a situation where a judicial review application makes a lot of sense.
Mm-hmm. And Zainab, I guess on that point, and I know many folks are deciding between reconsideration, a new application, and judicial review. What are some of the major factors for you that lead you one way over the other?
Okay. Reapplication, I would advise where, there's a mistake, there's an error, there's something missing, and that can be resolved in a new application. But if someone's basically just saying, I don't want to go to judicial review, I just want to reapply with basically the same information and documents, unfortunately, I think the way, this is my perception, and I think, as we learn more about the way Chinook's working, we'll probably get this verified. If you have a previous refusal, it will probably factor into your application being refused again. And there's no additional benefit to getting a second refusal and then trying to JR that decision, right? So I think if there's ways in which your application can actually be improved, go with a reapplication. And if there's a clear error, like a very clear error, it's very difficult to get that with today's notes, like the kind of note that we just heard from this particular applicant where they mentioned something specific to his file. It rarely happens. The notes are so generic, it's very difficult to do, and it takes a long time to get those notes. So reconsideration, given the rate of success, you could try it, but I tell people the rate of success on that is very low. And then, on very complete applications where it was a very clear study plan, the documentation was clear, the applicant provided everything that we would normally, think of as a very complete application, I think judicial review makes a lot of sense there.
Well, okay, so I think just in the interest of time, we may have we have room for two more questions. And there's one that I've been actually itching to ask here. And this one's from Asma, adding to Shireen's question earlier. And Shireen's question is about the lack of procedural fairness and basically how do they justify this use of money, the colossal amounts of money for adjudicating TR applications, for example. And Asma's point is, how do they justify the outrageous processing times on top of the outrageous amounts that they're actually spending? And I think, guys, watch out. Zainab and I are actually working on a piece about, the cost of actually having to litigate TR applications, why it's not the best solution. That basically, as taxpayers in Canada, we're basically footing the bill for this. Why are we adjudicating TR applications by way of the court? And we also know that the federal court has limited resources, right? So thoughts, let's start with Will this time. And I know that this was Zainab's party, but let's flip it around now.
Yeah. Well, I can't wait to read your piece.
About the resources?
First of all, I can't wait to read your piece. And I think more transparency around judicial reviews is so needed right now, right? Because other than the rules and the process, I don't think the toll and the impact, and especially when folks have to defer their studies or, if they came just for one specific event and that event has passed now, so they have to come up with some other reason to come, and it really just throws plans all over the place. So I would say that to the processing times question. But I agree with all of those who are watching and asking this question. First of all, shout out to Shireen. It's like Shireen's following us on a bunch of stuff. So, props to Shireen for continuing the conversation. I think we need to be, I would like to see some sort of intermediary mechanism for us to be able to flag when a Chinook refusal comes through without having to start a federal court matter. In essence, a better reconsideration process, perhaps. I would like to see them stop using that first, the automated refusal template, but I think there needs to be a better way for applicants to put to attention to immigration. Listen, you can't Chinook me. I don't know how it's going to work, but that's what I'd like. And I think it would cut down on the number of judicial reviews and the cost and the delays for everyone.
Yeah. And just following on what Will's saying, I mean, unfortunately, there is this huge additional cost. We don't know the exact dollar figure, but we can sort of, work around, figure out how that is impacting us. But I think another part that kind of fits into all of this, which goes back to Shireen's initial question about procedural fairness, is, a lot of people don't know how Chinook is making these decisions. And we've talked about this before, but if applicants had a better sense of what it is that the officers want and what profile they're actually going to accept, and, that might not be ideal, but if they're really not going to accept certain people of a certain age or above a certain age or from, no educational background, so on, those guidelines should be much more clear. There is a huge human cost to this. People have hopes and dreams, and they go through this and they actually, in addition to the hopes and dreams, they actually spend money, they get acceptances, they do language exams. And, maybe they hire a local agent or they hire somebody to do this process. And so the $150 application fee is probably the smallest aspect of this whole thing. And I think part of this whole, rethinking of how the system could work better is we could have more manageable volumes, perhaps, if we had more clear guidelines of what it is that we're looking for. And IRCC, if they put some resources towards making that more clear, then they will avoid a lot of this kind of back end backlog and so on that we're talking about right now. I think those go hand in hand.
But I think there's a fear, just to engage with you. I know we're heading close to the end of our show and we want to talk about what we're going to do in the next season. But one of the fears is if we do move to an Australian model, the one, 95% approval rate, less people applying, is how does the system at its current state either split up the spots if it's a quota system or, how does it not discriminate on the front end? Because I think the whole reason for some of these systems is there was a thought that if we just do this in the behind the scenes, either no one's looking or no one knows, and we can kind of get away with it, which I know we've kind of frustrated that process a little bit by trying to speak on these type of things. But if you put at the front end, then you really have to engage with hundreds of years of discriminatory history against applicants from Africa, Francophone, African applicants, individuals from the global South. And if we put that out there, are we comfortable as a country saying, hey, listen, we're just going to limit the number of spots for applicants from certain countries because that's all we can take from that country? That's a question I'd have to ask, though.
I agree with you. It's a very, sorry, Lou, just one quick point. I'll say, I think it's very uncomfortable. And, one of the things I was going to talk about today is, I am so happy that we're in this space in 2021, going into 2022, where we can talk about these topics and we can talk about the history of bias that we have within our decision making. But I think hiding it within this context of anybody can apply, we're not restricting it, it's not exactly fair, because we do impose high costs on those applicants that do come from certain parts of the world that are going to get refused, right? Where $150 and the other expenses are actually significant expenses for them. I am certainly not advocating for a quota system. And I do realize that some of the requirements that we put in will necessarily probably translate into, people from a certain socioeconomic, background can apply. And that's unfortunate. And I think it's much better for us to have those conversations up front and for us to be part of those conversations and create perhaps other mechanisms that we can use to sort of, deal with those, as opposed to having a system that appears to be anybody can apply. It's so easy to do, but then the result is, we look at the acceptance rates and they tell a different story.
Absolutely. Lou, your thoughts?
I'm gonna parse through. I'm gonna skip on making a comment about that. Actually, I think I'm gonna blend my last comments into the closing remarks here. But I would like to raise one more point, and this is from Truth First. He did ask a few questions earlier. The one about the GCMS notes and the vague notes was from him, so thankfully we got that dealt with, and with Mario too, right? But there's another point that he raised that's actually very interesting. So for people in countries where they don't really have a decent income vis-a-vis Canada, where lawyers may be out of reach in terms of like costs.
Mhm.
What can be done? And I think Will hinted about this earlier in terms of having like a mushy middle intermediary. If you know it's been Chinook, maybe don't go to JR. Maybe there's a way to actually review this. What are your options? And actually, let's talk about that, and then let's talk about the actual costs of judicial review. How about that?
Wow. I love it. Put the pricing on the table. Clients always ask, tell us how much it costs. This is good. I like this. Okay. Zainab, you start.
I think it's a very important question because it is an access to information. And one of the ways I've tried to approach this myself is, participating in these conversations that are available internationally and that there's no cost associated with it. And, each of us can do our own piece in terms of, like, I do also resources in Farsi. So, a different market can have access to correct, up-to-date information. It's not legal advice, but it's general information. And this is how the information is getting disseminated, right? So I think that's an important aspect of it. I think as lawyers, we can use a part of our, pro bono work or hours or whatever you want to think about it, to raise awareness about these developments and to put, it's fascinating. I have, like, in almost all of those other presentations that I do, I will go through what a complete application looks like. And so there is a lot of information available for people who do want to access it. And I hope that it will be more and more as we go forward, as me, yourselves, and other lawyers out there are engaging in this kind of work. And it's interesting because you remember right at the beginning, I mentioned it's about how we provide services to our clients. And I think, more and more lawyers are turning to this idea of, they used to be really afraid of having legal conversations or writing legal pieces because it would be interpreted as legal advice. But I think we're getting to a point where people are recognizing, no, you can talk about a topic and provide general information without it being considered as legal advice. And as we see more and more of that, I think people will have access to it. Overall, I'm not sure how a system where, an intermediary sort of review process would work in IRCC. They already have limited resources.
Yeah, it is tough.
And it would take a long time for them to implement something like that. Unfortunately, I think litigation and federal court might be one of the only options available for people. And, for example, I have reduced my fees significantly for these kind of JRs that we do for students. But they do require a lot of work, and we still get settlements. But before we used to get settlements faster, and now we actually have to do a lot more work before we get that. So, I think Mary also mentioned this. We're trying to keep the costs as low as possible compared to other kind of litigation work that we do in Canada. But it's a reality. It's something that it makes the system even more unfair, unfortunately.
I agree entirely with what you said, Zainab, and I think you're doing some incredible work, especially in the Farsi-speaking community. And I would add that, like, language and making information more accessible in different languages, the role of translators and interpreters globally to help make sure that that's accurate information is so increasingly important in today's world, because a lot of this immigration conversation gets thwarted when in local markets, folks that are agents that aren't authorized in Canada, but Canada has no reach over them, and what they're doing start spreading misinformation, right? And even, I know there are folks making money, and Lou mentioned this, on YouTube, trying to make study plans and, trying to, show themselves off on screen to try and, make a couple dollars. Like, be careful, be cautious of that, right? Call it out. Let, if one of your friends is swayed by that, say, hey, listen, you might want to just check in with someone on that. You double check, do your due diligence, right? They're great. Like, these forums, these things that are increasing the conversation are great, but they need to be dealt with an appropriate level of, I need to verify, I need to double check. And I think that I'm seeing that, though, from those who follow me and those who are engaging with me, that, there is, folks are trying to help each other out to avoid getting defrauded and getting misrepresentation findings and taking the wrong path. And that's hopeful to me, if you're talking about the word hope. So yeah, that would be my 2 cents.
Speaking of hope, let me get to that in a second. But to address this particular question from Truth First, let's talk about options. 2 points, right? Options and the JR question. Options, I am with Zainab, I am with Will. It's very difficult to deploy something that would be something of an intermediary to kind of like, get this reviewed. If it were, we're talking about volumes in the hundreds of thousands here every year just for study permits. So I'm not sure if this is something that IRCC would even start to look at. So I'm sorry to say that. Now for the second point on judicial review, I want to say 2 subpoints about this. First is to the clients. Yes, it can be expensive. Litigation is not cheap. I think we're all in agreement with that. But just like Zainab, and in our practice here at my firm, for example, we have reduced rates specifically for study permit refusals, specifically because we know what's going on. And there are ways to actually combat, the government in terms of how to reduce the rates, so to speak, for your clients. Let's talk about automation of document generation, for example. If you're using platforms, speaking to lawyers now, for example, there are ways to actually streamline your process to actually do a judicial review application package together with your client. Now, it depends if you actually did the application for the study permit, for example, with your client. It would be an easy walk in the park for you. But for those who did not, there are still strategies to get around that. So, for those lawyers who are curious, DM me. I have some tips. I'm very happy to share them. Now, the other point is to clients. Let's face it. The fact is we do have to pay for this if you're going to do a JR. And unfortunately, there are no options, as Zainab was pointing out. But I would like to use, for example, the perspective of applicants from the Middle East, even in the Philippines. They're paying upwards $3,000, $4,000, $5,000 for study permit applications. If you talk to firms in Canada, especially the ones who are specialized in study permits, I'm looking at you, Will, and Zainab, for example, for judicial reviews, then you'll find that their costs are pretty competitive.
Absolutely.
And if you balk at the number that they give to you, then talk to them about your options. Be honest about like what your means are. And, these lawyers are also human. We also have families to feed. So we're also very sensitive to prices. But, if that conversation is not happening, there's no progress, right? So that's just a sad reality there, unfortunately.
The one thing I would want to shed the light on, and I know we said costs, but it's hard. And some firms are posting their fees online saying we're starting from this point or whatever. For me, because I provide such an individualized service and I really depends on where I see this file going. If you're refused on one ground that's completely unreasonable versus 3-4 grounds that actually might be a fight, it changes the scope, the milestones, where this could go. Every single case, right? So if there's a reason why I'm not saying, hey, my charges for judicial reviews are X amount of dollars, it's not because I'm waiting to see how much money is in your bank account so I can bulk you more. And I think that's sort of the misconception on lawyers. It's literally, I have to predict how many hours this file is going to take for me because of your unique fact situations. I can't just copy and paste the judicial review I did last time, right? And it's not, we don't do corporate point of entry work. Again, no offense to corporate, immigration lawyers, that's great work too. But, we can't just repeat the same letter and just change, your name because you're an employee of a company. You're already someone on a, refusal list, very specific, we have to uniquely target, your case with your particular fact pattern. And it's very different from just a simple application at the border.
If I may use a medical analogy, you wouldn't let a surgeon start operating on you if that surgeon didn't conduct their due diligence by doing an x-ray, for example, right? So all Will is saying is that each case is unique, and unfortunately that does carry additional costs with it. And on that note, actually, I'd like to move on to the final point of today, because I'm very worried about time as well.
We spent a little extra time, but that's
we did. But I think I love this conversation. Honestly, I could go on. Unfortunately, we do have our own commitments. So let's talk about season 2, Will. When is it happening?
Well, season 2, we're going to have it for quarter 2. I think for many reasons, the beginning of the year is going to be a little bit stressful for a lot of us with family commitments, with a few things we got going. We're still going to do special episodes as we see, appropriate, but we will do our full season starting in season 2, and starting in quarter 2. What month would you say? I mean, we can't really put a exact month on it, but probably would that be like March, April-ish?
Something like that. Yeah, I would say.
Something
Would you
like
agree,
that.
Zainab?
Yeah, I think that sounds about right.
Yeah.
Mhm.
And we want to make this season a lot more interactive and engaging. You're going to see the quality of our work hopefully skyrocket. Again, we put a lot of our volunteer hours into this. This is, I would say, akin this to almost being like a board member of something or a volunteer on an organization.
Mhm.
We put, sometimes for these episodes, we spend 5 to 10 hours writing them, right? And this goes behind the
Right.
scenes, securing the speaker, building it all out. So this is in addition to our full-time legal practices. So hopefully this is
Mhm.
something you guys all enjoy, but we want to see more interaction from you guys as well. Who do you want to see on this show? Add us at our Twitter handle. I know Candy can share it with everyone. We're out on Twitter, but add us
Yes.
and let us know who you want to see on the show, because there's some brilliant minds out there, not only just in the dorky sort of immigration mind, but just really good immigrant stories that we want to understand and build and learn from and inspire us with. And I think we're trying to balance that, make it connectable and relatable to regular folk. I know Mario was talking about as well. Super important. We can't just create this resource for lawyers and litigators.
Absolutely. Any final thoughts? Let's start with Zainab.
Sure. I touched on this a couple of minutes ago, where I just feel really privileged to be practicing at this time and for us to be having these conversations. I probably even 5 years ago, I couldn't really imagine us having such open conversations about priorities and policies and in immigration. And I'm very happy to see so many other lawyers are engaged in this, and the opportunity that there is, whether it's through this podcast, whether it's, I think as engaging on other forms of social media and like Twitter and so on. But for me, it's a very exciting time. And I'm learning so much every day. And I hope that, I can play my little part in sharing what I learn on hopefully a regular basis. But I just find it to be a fascinating time, and I'm very happy to be joining the show, and I'm looking forward to season 2.
We're excited to have you as a third co-host, actually.
Mm.
We're really excited to hear the perspectives that you're about to offer, especially with your rich experience in the last 10 years, as you mentioned. What about you, Will? What are your final thoughts for today?
Just a lot of gratitude. I mean, for those who, I'm not going to go too public on this, but thinking a lot about 2022, what that looks like for me and my family. And I'm so passionate about this work, balancing the business side with things like this, which give me so much joy and allow me to spread sort of the knowledge that we learn. This is a conversation that I needed. This felt almost therapeutic to be able to take the whole year of sort of the Chinook worry and even leave it with a little bit of sliver of hope. And I think that I'm grateful for Mario for bringing that up. I'm grateful both of you for bringing that hope, because I think I've been lost in a little bit of that dreary, I don't feel prepared. Next year is going to be terrible. And now I feel like there's a little bit of inspiration that we can all take away from this. And I hope that you all spread this to your friends, your family, those who are thinking about immigrating. Just let them watch this episode, right? And maybe they'll learn something, maybe not, maybe they'll become passionate in it. And I hope that we can all sort of, as a ImmLight army, do the work and spread the joy of our work and the impacts on everyone.
Well said.
Oh, powerful words. Thank you, Will. I appreciate that. And I appreciate the both of you doing this together with me. And Will's right. We do put a lot of hours, efforts, in spite of our very busy schedules at the professional and, personal levels, our families, of course. I want to end on a couple of things, actually, just like going back into the whole theme of the episode. And I want to finish off on hope. I hope to finish on hope. The first is that basically, this message goes out to IRCC, and I'm very thankful that there are folks inside the department that are still working very hard, despite the current difficulties of families, being separated, despite the difficulties that international students are currently facing, refugees, especially as we head on to the holiday season. But what we're trying to do here essentially is not to attack. We're trying to have a conversation, and the thing about it is that there's really a deficit of information at the moment, and we would love for it to be a public conversation where it's possible. And we do understand that there are program integrity questions that we need to be mindful of. There are malevolent and malicious individuals out there who are out to get the system. Just over the weekend, for example, there were hacking attacks, for example, against the government of Canada. So we're very aware of that. But we want to make sure that there are assurances that, the biases that we just talked about would not be embedded in a system that would facilitate the good work that our friends over at IRCC do. Their work is very important, and we want to help. We really do, and we want to be facilitative as lawyers, as immigration consultants as well, that basically, if an application goes in, what we want is the application to be very easy for an immigration officer to have a look at and get that off their desk, so to speak. But given the current climate, unfortunately, where the department is being accused of internal racism, and we're talking about specifically the question of racial bias in, say, for example, Chinook or Hiraya or what have you, then questions naturally will pop up. I think IRCC should join the conversation and really clear the air. I think that's the best cure, to put everything under the sun so that people can contribute. I think living in a democracy, it's a part of it. They shouldn't be afraid of their citizens. They shouldn't be afraid of their stakeholders. We are here to help. We're not here to attack. So that's one point. And on the point of hope, Hiraya, one big ask for immigration, and as Will tweeted the other night, can we stop using indigenous words, please, and reappropriating it to these, honestly, guys, like Chinook, Hiraya, and Hiraya, by the way, is from my mother tongue, Tagalog. It means a spring well of hope. Not sure if the name actually is appropriate, considering that, we don't know so much about it. It's actually kind of like the opposite of it, to be honest. Let's not do that moving forward, please. And with that, thank you to my co-hosts. Wonderful. Have a wonderful holiday season. I hope that everyone has a reflective and a blessed season in the coming weeks. Please stay safe.
Yep.
And thank you very much.
All right. Take care, everyone.
Thank you, guys. Bye-bye.
See you in 2022.
See you in 2022. Bye-bye.
Take care.
Bye.